Oh, they already did it.
Close the session, please be seated.
Good morning, and thank you for your patience while we reconstituted the panel. So this is the last case we're going to hear for argument today. Number 2020-1299, Commonwealth versus Stephen Bankert. Is that correct?
Yes, Your Honor.
Okay, thank you very much. All right, let me begin.
Good morning, honorable panel. If it pleases the court, my name is Stephen Bankert. I'm the defendant in this case.
Could you move the microphone up towards you a little more? I'm sorry.
Is that better?
Yes,
much.
Okay. Thank you.
All right. The testimony by the Commonwealth in this case on the gas meters was only by laypersons. Expert testimony was never offered. In fact, it couldn't be because their witnesses couldn't qualify as experts. What they found were scratches and screws. Whether these scratches they found on the meters affected the operation was not something a layperson could testify to, only an expert. It's not just damage that violates the statute, it's damage that affects the operation of the meter. These gas meters were, as I'm sure you know, at my different laundromats, and this is the subject matter of this case. A meter is a technical machine, not something a layperson would understand. Explaining the operation to the court and jury and what would affect the operation should and would only require an expert, no one else. A technical machine should not be prima facie evidence when only verified by someone who is not an expert. Anyone can see a scratch or a screw or think a screw is out of place, but only an expert can testify that the scratch or screw would affect the operation. This was an abuse of discretion by Judge Tucker, who actually questioned his own sound judgment. On trial day 3, page 4-7, line 22, he called it a fine line and referenced how his view doesn't always align with the appeals court. He doubted his own decision. That's not discretion. That's a doubt in his mind. A properly functioning meter can have a scratch, a screw, a gear, or a shaft. Only an expert can testify whether the meter is working properly. By allowing a layperson to give testimony to these items leads the jury to believe that these things are somehow different and important.
Can't the jury infer from the fact that there were significant changes in the amounts of gas that were being registered over periods of time, and at least some of the laundromats, that there was in fact an effect from what was observed?
Yes, they could definitely draw that. I see your point. They could definitely draw that conclusion, but how that meter got damaged then became the question.
Okay. So, I mean, because I understood you to start with the notion, A, that the statute actually required a reduction in gas, which it doesn't by my eye, but I didn't see that in argument in the briefs, and so let's just pass that. The question I thought the briefs focused on and that you focused on now is, what was the evidence that the defendant, who I take it as you, had actually caused this any injury, disconnection, removal, or otherwise to the meter itself, right?
Right. There never was evidence that directly linked me to any of the damage.
Well, we have these people in their non-expert capacity, and they may have testified in their expert capacity as well, although they weren't properly qualified. But in their non-expert capacity, they say things like, I've been doing this for a long time and I've never seen this kind of damage before in a meter, and yet somehow at 6 or 7 laundromats, all owned by the same person, it's done. Surely that could support an inference, right?
It could support an inference if of course that was found to be true.
Yeah.
We never got to that point because the meters came in without any expert saying all of them had that damage.
Well, there were people saying that weren't they all described as having cut security wires and maybe something else, a movement of some magnet thing. I don't know how they work, but something.
Well, and therein lies part of the problem. The meters themselves never really had a good chain of custody. Some of them were thrown away. Some of them were put back into service after they were examined. We don't actually know. They never took pictures, believe it or not, of any of the meters where they claim they found a security wire cut or they claim that there was damage.
Well, actually, as I read some testimony last night from one of the witnesses who said, here is the meter, and that's the security wire, and it was cut, and that's how I found it. Isn't that sufficient to establish that kind of damage to the meter?
Well, there was no proof, first of all, that a security wire was there, and we never saw a cut wire. There was just somebody's testimony that when they received the meter, because the people who took the meters off the building didn't testify, it was the people who received the meters back at the office, sometimes a week later, that made these reports. So to take a meter off may require cutting the security wire. And while that never was explored, it should have been. It should have been.
That's a slightly different question. Are you saying that there wasn't sufficient evidence before the jury to establish the elements of the offense because of the fact that there was no expert testimony? Or you're saying that the lay witnesses didn't provide the jury with sufficient observations as to the fact that the meters had been damaged in some way?
Well, what I'm saying is, to be prima facie evidence, it should be cleaner and better than what this case had. To put it in a short way, the idea of prima facie evidence is explored in Commonwealth versus Littles. And in there, that was a check-kiting scheme. There was a paper trail. And the woman was given an opportunity to make good. She was confronted, shown the deficiency, and given a 2-day opportunity to make good on that check or that overdraft. When she didn't, that maybe not, but that may be the point where it rose to prima facie evidence. In this case, prima facie evidence was basically, here's a meter, and there's a lot of circumstantial evidence, but you don't have anybody telling you that all of these things caused this. We know 2 things happened, but because it was prima facie evidence, the Commonwealth never linked the 2 together.
Well, are you saying they never linked it to a loss of to less gas, or they never linked it to you as the person who caused damage? I mean, there's multiple things going on, counsel, or Mr. Bankert, and I'm trying to figure out which one is being argued. I understood the briefs to be arguing that the presumption that the statute prescribes and the jury was instructed on eliminated an element of whether or not you were the person who had done that. I hear you arguing something different today, which is that there was insufficient evidence that these were in fact damaged in any significant way. That's not an argument that I saw in the briefs.
And perhaps I read into it mostly because I've lived through it. But the point I'm trying to make is, to be prima facie evidence, it needs to be cleaner and better than what this case presents to this appeals court. The opportunity for a meter to just be placed and then show bills. At trial, we showed that several of the meters were either not inspected or worse, were broken before they were installed.
Okay, but the instruction is the existence of any injury disconnection, removal, interference with regard to a gas meter or attachment shall be prima facie evidence that a commercial or industrial business to which such gas is at the time being furnished by such meter or attachment, with intent to defraud, created the conditions so existing. So if the jury concludes there is an injury or damage to meters, this instruction says you may infer that it was caused with intent to defraud by the business. Now, surely they could have found that these were injured or damaged meters, right?
So there is no question that some of the meters had some damage to them. Whether that rose to the level of interfering with the operation of the meter was never answered.
It doesn't say that. It just says that maybe, I assume it has in mind, I mean, it's terrible instruction in my view, but I assume that what it has in mind is maybe the person attempted to defraud and failed. So it doesn't say anything about gas usage. It just says if we find this at a business, the business may be found to have caused it with intent to defraud. Or we have prima facie evidence, which I'll ask certainly your brother whether this has to be, whether it's rebuttable even, or whether it's just a presumption of an element of the offense. Let me ask you this, though. This says that the business did it. It doesn't say that an individual did it. Were your businesses sole proprietorships? Was there any evidence of that in the?
Some of them were corporations. Some of them were limited liability companies. So to assign it to me personally, that was another of my arguments. I didn't necessarily feel that because I was the person responsible for paying the bill, that I became the guilty party, so to speak.
Were you responsible? Did you have counsel at trial, or you litigated this yourself?
I'm sorry, say that again?
Did you have a lawyer at trial, or did you represent yourself?
I had a lawyer at trial.
Was there objection to this instruction?
There was.
On what ground? Do you recall?
I do not recall.
Okay.
There's an extensive transcript, obviously.
Yeah, I remember some of that, but I hadn't noticed this business part until just now.
I hadn't either.
But there was evidence that you were responsible for the utility bills at all the laundromats, correct?
And actually, no. I was not responsible for the utility bills at the Lawrence facility. That was a management agreement. And that bill was actually in the landlord's name, not mine. So there was a disconnect there also.
Well, there were 6 laundromats. Were you responsible for the other 5?
Brockton was a management agreement, and one of the Worcesters were a management agreement. So that would be 3 and 3.
What does that mean? Responsible for a management agreement means that you were not responsible for paying the utility bills and reviewing them?
I made the payments, but I was a manager, not an owner. It's a very fine distinction, and I didn't intend to spend any time trying to make that distinction.
Well, first of all, you should confine. We're not taking testimony here
at all,
under any circumstances. Okay?
I get that.
So confine whatever you say to what was in the record.
Yes, that really. Well, if I had been allowed to testify, that would have come up.
No. You need to confine what you argue to what was in the record, so that we understand and can look at the record to see if that's what was there.
Yeah.
Including what you said in your affidavit and what was said in the motion for new trial, which I wanted to know if you want to mention anything about now, because you only have about a minute left of your argument.
Yes. I wanted to talk specifically about the sidebar that my attorneys had prior to trial. Mm-hmm. Very quickly, and there's no nice way to say this, they lied to the judge. They told the judge I was non-communicative. Motion day was Friday. On Friday, I learned that they had filed an incorrect motion. I learned...
How were you injured, though? Their motion was denied.
I was injured because they presented to the judge a false image of me.
I see.
And the
Okay, I
judge...
get
They didn't say that you were not communicating with them. They said you were not communicating about trial strategy, not that there had not been no communication. I saw the emails that you have provided in support of your motion for a new trial, and I read the sidebar conference, and it seems to me what the attorneys were concentrating on was a lack of communication regarding trial strategy, not lack of communication, period. Is that correct?
No, I'm sorry, Your Honor, but that is not correct. I know my time has expired.
Yeah.
But
I'll review that again. You say your point is that they represented that there was no communication, and that was later refuted.
And I believe
in your motion for new trial, you believe it was refuted.
Yeah, and I believe the trial judge erred because he could have asked me what was going on, and he didn't. He only took their view, and he failed to verify with me, was I really not communicating? I know that the emails you got are...
I'm going to stop you there because
Okay.
you have, of course, the hearing and all the affidavits that were filed and the decision on the motion for new trial. But even though we're over, let me check with the panel to see if they have any additional questions. So they don't. So at this point, what happens is that you rely on your brief. None of the arguments that were made in your brief are waived, even though we didn't talk about them specifically here. They'll all be considered. Okay?
Thank you, Your Honor.
Thank you.
Good morning. May it please the Court. Assistant AG Gabriel Thornton for the Commonwealth. To be clear at the beginning on the jury instruction issue and this question of whether there's a meaningful distinction on the evidence in this case between the defendant's businesses and the defendant himself, there's not a meaningful distinction there, to be clear. I thought about this, and I was actually one of the prosecutors who tried the case. The very first piece of evidence the jury heard was a stipulation that the defendant was responsible for all the utility payments at all of the laundromats. Now, the statute, whatever we think about it, it does talk about a business as opposed to an individual who runs that business or works at the business. But
was there a specific objection by the defendant to the word business?
No. The objection and objections, I think they were made at different points throughout the trial and before the trial. Well, not before the trial in terms of the prima facie evidence instruction, but I think the prima facie evidence instruction is discussed at multiple parts of the transcript. The objection there was burden shifting, essentially.
Okay, so can I ask you a question? Where did the second and third paragraphs behind the language about prima facie evidence, where did those come from? The paragraph that says, by prima facie evidence, we mean first that you must consider this conclusion that the business treated the existing condition unless some evidence which you find believable is introduced to the contrary. Where did that come from?
I believe that came sua sponte from Justice Tucker. This was not an instruction that we had requested. Best I remember, there is no model instruction on this offense.
Was there an objection
that's
about
correct.
that? Was there an objection?
Specifically, no.
But they said the instruction constitutes burden shifting?
Correct. And there is a bit of a discussion there by defense counsel.
Doesn't it constitute burden shifting? Doesn't it constitute unconstitutional burden shifting?
No, Your Honor. It's not unconstitutional burden shifting. And I think what's helpful here to that argument is some additional language that Justice Tucker added on the Commonwealth's burden of proof. Of course, as we argue in the brief, even if there's a question about the constitutionality here, any error was harmless beyond a reasonable doubt.
Well, how can the burden of who did this not be harmless beyond a reasonable doubt? You don't have a picture of the defendant tampering with this?
Well, Your Honor, I believe it's a question of potential burden shifting. To be clear, I don't think that there was burden shifting.
Do you agree that prima facie evidence does not mean there is an irrebuttable presumption that that element has been proven? Do you agree with that?
I agree. There is a rebuttable
so
presumption.
do you think this is an error? You must consider this conclusion, and I'll add that the next paragraph then reads, secondly, if believable evidence to the contrary has been introduced, then you are not bound by that conclusion, implying that what he meant before was you're bound by this prima facie conclusion.
It could have been worded better, Your Honor.
Could have been worded better. I mean, I didn't see a cite to Francis against Franklin, but isn't this Francis against Franklin? Did you read Francis? You know the case I'm talking about?
I'm not sure.
You may presume, but the presumption can be rebutted, held to be unconstitutional by the United States Supreme Court.
Yes, I understand. But I think when you look at the transcript in its entirety and Justice Tucker responding to defense counsel's concern about this instruction and adding additional language in addition to the typical burden of proof instructions about how the burden was not shifted here.
So where is that language? Where is the language you would rely on to save this?
I don't have the cite.
Is it prima facie evidence does not relieve the Commonwealth of the burden to prove the charges beyond a reasonable doubt?
That would be, that's primarily what it is, Your Honor.
But that doesn't help us because, of course, they have the burden. They've met it by showing that injury was done to the machine. And then the statutory presumption, at least under the instructions, in the absence of believable evidence to the contrary, seems to wrap that element up, doesn't it?
I would disagree, Your Honor. I think there is still a rebuttable presumption there, and I would point out that the jury did hear from the defendant's expert about what may or may not have caused this damage, and that is evidence that the jury could have accepted for the presumption to be rebutted.
I'm sorry. Could you just say that again? I was reading this.
Yes. The defendant put on one witness, his expert witness, and the jury heard from that expert witness, among other things, that the damage in question here was not caused by the defendant. And they heard a lot about that, and that is evidence that the jury could have used to rebut that presumption.
If we conclude that the conviction rested upon improperly admitted expert testimony, what do we do?
As I argued in the brief, Your Honor, I think that any error there could still be overcome by the strength of the evidence against the defendant.
Well, so we have people who supposedly are not experts telling us things like, when you move this magnet down this thing, and I don't have a picture of it, I don't really know what I'm describing, but they say that, then it will make the amount of usage appear lower than it actually is. That seems like obvious expert testimony to me. I know that without specialized training, who would know that? And if I were a lay juror, I would have no information about what moving a magnet or whatever or cutting a security wire and moving a magnet. I have no idea what those things do. I need guidance on that. That seems like expert testimony.
If I remember correctly, the testimony from the gas company employees who examined the meters was that this damage affected how the meters functioned.
How do you know? How do you know that?
From reviewing the testimony.
The testimony of these non-experts say that damaging the meters in this way affects their function.
Yes.
And you don't think that's based on specialized training or knowledge, that it would be outside the ken of an ordinary juror? This isn't like if you poke a hole in a tire, air is going to come out. This is how a gas meter works.
Your Honor, it's not quite as simple as the hole in the tire, but it's actually not all that far away. And at bottom, it was not
really?
an opinion.
What if I crack the glass on top of the meter? Will that affect the usage?
Are you asking whether the jury heard any?
No, I'm asking you. You say it's like air coming out of a tire. What if I go to my gas meter at my house and just crack the glass? Will that affect the usage?
It could, based on what I know. I'm not sure if there's any evidence.
Do you think maybe someone with specialized training could tell me? Because I don't know. What if I heat the meter up or put ice on it and cool it down?
Again, Your Honor, they did not testify to whether it affected usage. They just testified that this damage to the meter indexes or heads affected how the meter indexes or heads functioned. And then the jury would need to look to the additional evidence of the usage from the bills or other gas company records to draw that inferential step from the damage to the meters to the decrease in usage.
Do you know whether temperature can affect the measurement of gas usage? Objected to. Do you know what effect, if any, a bent ERT drive pin would have on the measurement of gas? That was objected to. Can you explain for us what, if anything, happens when a magnet shaft drops down and disengages? I don't know the answers to those questions. I didn't actually, I'll confess, I had my law clerk list for me the questions that were asked, so I haven't looked at all the answers yet. But those questions, in my view, maybe you think that's like air coming out of a tire, but once we're talking about ERT drive pins, that seems like expert stuff to me.
With the question of whether it's expert stuff or not, we start with the question of whether it's fact testimony or opinion testimony. And these
I know you say that, but how does the ventricle of a heart work? Do you think maybe we should get a doctor in to answer that? Or that's just fact? A non-expert should be able to tell us how a ventricle works. Because I don't know the answer, but I think in a medical malpractice case, you're going to want to have a qualified expert.
I agree with that last point, yes, Your Honor, but I do think a fact witness could explain how a ventricle works without offering opinion.
But do you think they have to be qualified as an expert to do so?
No, Your Honor.
So you think I can bring in any fact witness, and without asking any questions about training or experience, I can ask them how a ventricle of a human heart works?
Not without asking questions about training or experience. I think we would need to establish that this person...
You have to lay a foundation for them to be able to answer the question. Doesn't mean that they're an expert. You have to lay a foundation. It has to be sufficient.
Yes, which was done here with these gas company employees.
Can we? I'm sorry.
No, please.
If you're, I don't want to. I want to.
No. It's. I mean, I'm interested in this question. I understand there's difference between fact and opinion. I'm not sure how different laying a foundation for expert fact testimony is. I mean, I'd have to look at the case law about that. There's things where I would certainly want someone to have said essentially all the things necessary to qualify a witness about their ability based on training and experience to answer the questions. And I don't know. I will look, obviously, at what foundation was laid for these witnesses. But to me, it seems like these require qualifications. Fact. Okay. I mean, there's almost no opinion involved.
Another question.
Go ahead.
I'm stunned by an answer I got earlier. So I regard the instruction, I'm back on the jury instruction, I regard the instruction as having three components. The first component of that instruction comes directly from the statute, can only be challenged under a line like the Little's case or whatever the name of it is. At least from my eye, I don't have a problem with that. But what I hear you saying is that the second paragraph, the definition of prima facie evidence, and the third paragraph, which goes even further, as Justice Rubin points out, were done by the judge without anyone asking for it?
That's correct, Your Honor.
Did he show you what he was going to instruct in advance?
Yes. And if I remember correctly, you're going to find this discussion at the beginning of the transcript for the last day of trial, or at least the day on which the closings were given. And I believe there was an earlier discussion as well, but this particular instruction was, if I'm right, was discussed again.
Is there anybody who said you have to define prima facie evidence, or he just did that on his own?
If I remember correctly, he just did that on his own. And I'll admit, as I stand here, that in retrospect, we would have been better off without this instruction being given. We didn't need it. We were in the difficult position of having this statute that has the prima facie language, such as it is. Again, I don't think we needed it, but the judge deciding on his own that because of the language of the statute that he would give this instruction.
And there was an objection.
There was an objection.
I'll go back and read it.
Certainly. And
that it was burden shifting.
In response, I would disagree, Your Honor, but in response to that
No,
discussion...
that was the objection was, this is shifting the burden to the defendant.
Pardon me. Yes, it was. It was. And in response to that discussion, Justice Tucker added in some additional language, and at least part of that additional language was this, I guess would be the fourth or fifth paragraph about does not relieve the
Prima facie evidence doesn't relieve them of the burden of proof. Okay. I mean, the instruction that was given in, I can't remember the name of the case. Is it Little's? Is that what it's called?
Little's is the leading case.
That instruction actually on this subject is perfect. It says you are permitted but need not. Okay.
I would agree, Your Honor. And just on the expert testimony issue, I would like to point out to the court that every one of these meters, well, 9 of the 10 meters, one of the meters was no longer around, unfortunately, but the other 9 were all in the courtroom, in front of the jurors, disassembled in front of the jurors, and additionally, an exemplar meter, a meter that had not been damaged in any way, was also opened in front of
Didn't some of the people who testified had actually removed the meter from where they found it, right? From the laundromat itself?
That's correct, Your Honor.
And they said, I found it with the wire cut.
That's correct, Your Honor. I would disagree with the defendant with respect to that. And if I remember it correctly, the Columbia meters, the Columbia gas meters, the jury did not hear from witnesses who removed those meters from the laundromats, but the Eversource or N-Star meters, they did hear from, I believe, 2 witnesses who had gone to the laundromats, were there when the meters were removed, and one of those witnesses was the witness who examined.
Make your best argument for why, even let's assume that we might reach the conclusion that jury instruction is incorrect. What's your best argument for why it's not prejudicial such that the verdict can be affirmed?
Yes, Your Honor, and it is in the brief, but that error would be harmless beyond a reasonable doubt, which even if this were constitutional error, the case could still survive if that error is harmless beyond a reasonable doubt, and that's essentially because of the strength of the case against the defendant.
How long was the testimony of these experts?
There were no experts.
No, of these non-experts?
The gas company employees, more than 2 full court days, if I remember correctly.
Okay. So your time is up. I have one actually housekeeping question. Is it in the record what happened to the meters? Were they able to be stored finally? There was quite an issue about that.
It's not in the record. I could inform the court if the court would like about what happened.
I presume they're still available.
They are.
Okay. That's enough to...
Not 9 of the 10 meters, yes.
All right. Any further questions, Justice Rubin?
I am good.
Thank you both very much for your arguments. We'll take the case under advisement and we'll render a decision as soon as we can. All right? Thank you very much.
Thank you.